available online and in the members' files as well. This is a public meeting and can be followed on UN webcast. This review is taking place in a hybrid mode with the Vice President of the Cambodian Human Rights Committee, His Excellency Mr. Chin Malin, head of the delegation, Secretary of State in the Ministry of Justice, and delegates from different ministries who are connecting from capital. I would also like to acknowledge the presence here of His Excellency Ambassador An, Permanent Representative of the Kingdom of Cambodia to the United Nations Office and other international organizations in Geneva. Due to the hybrid nature of this meeting, the consideration of the report will take place over 3 meetings of 2 hours each, allowing for a dialogue in 3 sections of the state parties' reports and the list of issues. I will now give the floor, welcoming once again the delegation, both in Capital and here in the room, to His Excellency Ambassador An for an opening statement. You have the floor, sir. Good morning.
Thank you so much, Madam Chairman. Madam Chair. Very good morning to esteemed members of the committees, Excellency, ladies and gentlemen. At the outset, I would like to thank the committee members and the Secretariat for facilitating the dialogue on the third periodic review report of Cambodia and accepting our humble request for the discussion to be in a hybrid mode due to the continuing uncertainty of the COVID-19 pandemic. Despite the ongoing health predicament, Cambodia has never shied away from its human rights commitments and obligations. Our hybrid presence today is a testament. Last year, Cambodia also renewed the 30 years old operational presence of the OHCHR field office and mandate of the country's special rapporteur, demonstrating the importance that Cambodia accords to the human rights mechanism of the United Nations. Cambodia has become a champion country for ratification of international human rights instruments, attesting to our resolute commitment to promoting and protecting human rights for all. The Kingdom has become a state party to 8 out of 9 core human rights conventions and has fulfilled its support obligation under the treaty mechanism. Madam Chair, distinguished committee members, human rights agenda should be discussed through a genuine dialogue-based approach with non-confrontation, non-politicization, and non-selectivity based on verified source of information and bearing in mind the national particularities and priorities of each country. A one-size-fits-all approach should be avoided. The enduring strength of all human rights mechanisms lie in the even-handed approaches with transparency, objectivity, and impartialities, as well as in full adherence to the principles of sovereign equality, territorial integrity, and non-interference, which are well enshrined in the UN Charter. I hope that today's conversation is constructive and balanced, taking into account the progress, achievement, challenges, and the perspective of the government. Madam Chair, the delegation of Cambodia is headed by His Excellency Chin Malin, Secretary of State for the Ministry of Justice of Cambodia, and concurrently serving as the Vice President of the Cambodia Human Rights Committee. He is also joined by senior officials of a number of core line ministries dealing with the primary issues that we're going to discuss today and over the next 2 days. With your permission, Madam Chair, I now would like to invite His Excellency Secretary of State Chin Malin to take the floor for his presentation. I thank you.
Now I would like to provide the open statements on behalf of the Cambodian delegations in the capital. Madam Chairs, distinguished members of the committees, Excellencies, ladies and gentlemen, let me begin by thanking the chairs and other members of the Human Rights Committee for having us at this meeting today. It is indeed a great honor for Cambodian delegations to be here with you to present the third periodic reports of Cambodia on our ongoing endeavors toward the implementation of provisions of the International Covenant on Civil and Political Rights, hereafter ICCPR, in our national context. First, I would like to introduce the delegation of the sessions as follows. For inter-ministerial delegations, we have Excellency Mobana, Secretary of State of Ministry of Labor and Vocational Training, His Excellency Mr. Pwan, Under Secretary of State of the Ministry of Information, Her Excellency Longsapali, Under Secretary of State of the Ministry of Women Affairs, His Excellency Pang Rasi, Deputy Head of the Legislation Council of Ministry of Interior. We also have delegation from members of Cambodian Human Rights Committees, Her Excellency Ojnipun, His Excellency Van Chandra, His Excellency Bantero, and Her Excellency Mai Minirut. And together, His Excellency Ambassador An Sekun and his colleague at the Permanent Mission of Cambodia to Geneva, who are present in this meeting room. Madam Chair, committee members, ladies and gentlemen, it is such unfortunate that due to the still ongoing COVID-19 pandemic and reoccurrence of an outbreak, our delegation could not be there in Geneva physically to report to you and has to conduct our sessions via online platform. On behalf of the delegation of Cambodia, I thank Madam Chairs, members of the committees, and all colleagues for your kind understanding by accepting our calls to do this third periodic report in a hybrid format. We are fully confident that the defense of today's sessions at this committee will contribute toward Cambodian effort in further enhancing the enjoyments of human rights of its people, including in the social and political rights. In this sense, Cambodians stand firm and ready to engage with all members of the committee to welcome all constructive suggestions, comments, and recommendations we will be receiving at this session with you. Chair, ladies and gentlemen, Cambodia is a nation that has endured a long-lasting civil wars and internal armed conflict, and it was only until these very recent years that the country obtained real peace and stability. Due to the tragic histories, the nation was plagued with the total destructions of its economy, starvations, and all other kinds of ill treatment during Khmer regime. On top of that, we have also lost qualified and valuable human capitals and our legacies. Thus, Cambodians understand fully well the true value of peace, freedom, justice, equality, self-determination, and other human rights. That is also the reason why we have worked very hard to promote and protect human rights in our national development process. So the promotion and protection of human rights is one of the government's most important tasks and also constitute the cornerstone in Cambodian national and foreign policies. In fact, the goal of government policies on human rights is to ensure full respect for Cambodian international obligations on human rights. Cambodia has strong will to promote and protect human rights, which has been clearly demonstrated through the ratification and the sections of 8 of our 9 international human rights treaties, making this country an outstanding one in the regions in the name of party to international human rights treaty. We acknowledge and share the understanding that in every country development process, the goal of promoting and protecting human rights and freedom must exist. At the same time, we also realize and recognize that the state goal cannot be achieved overnight. Therefore, we need both government political commitment and concrete actions, the support and cooperation from all relevant stakeholders, domestic and international, and patient and time. Ladies and gentlemen, now I would like to draw your attention to the most significant recent developments and update on the implementations of ICCPR in Cambodia after submitting the reports and respond to the list of issues. Number 1, measures against COVID-19 and human rights in Cambodia. The government has introduced necessary measures, including social, economic, health, administrative, and legal measures to prevent the spread of COVID-19, to protect the life of citizens, and to support their daily life, which guarantee and protect their basic right over the course of COVID-19, especially the right to life, socio-economic rights, and rights to access to health and medical service, etc. The introductions of government administrative and legal measures is not to restrict the rights and freedom and to punish its own citizens, but it necessary in this dangerous circumstance to protect their life, public orders, and public health, based on the principle of legalities and proportionalities. And these measures are not permanently taken, including mandatory vaccinations and identification of those infected with COVID-19. Apparently, in terms of ownership and preparedness, Cambodia has revised and developed new provisions aimed at combating and preventing the COVID-19 disease, including a basic law called Law on Measures to Prevent the Spread of COVID-19 and add the serious and dangerous contagious disease, in short, COVID-19 law, promulgated on 11 March 2021. A closer look at the penalty set out in the law relating to the COVID-19 revealed that while the penalties are serious, they are appropriate in the context of Cambodia itself and are designed to ensure effective law enforcement for the purpose of effectively combating and preventing the spread of this deadly disease. On the other hand, if Cambodian law is compared to those of other countries, penalties in Cambodian law are still lighter than those in Europe or Asia. The report made by special rapporteurs and other organizations of human rights aligned the government law enforcement measures against COVID-19 that at least 729 people have been arrested under COVID-19 law, and related regulation is not correct and misleading. Actually, according to the report made by subcommittees on law enforcement against COVID-19 from July 29 to October 3rd, 2021, it is reported that most of the people violating COVID-19 law and other related regulation have just been fined, educated, and allowed to return home. Only 44 cases with 115 people have been sent to court, 30 of whom have been detained for serious violation, and 85 have been released. Number two, update on the establishment of National Human Rights Institution. With the approval of the two Prime Ministers of Cambodia, this task has been assigned to Cambodian Human Rights Committee to lead and prepare a draft law on establishment of National Human Rights Institution. The working group of Cambodian Human Rights Committees has already finalized its first draft based on Paris Principle and international human rights standard, and the draft is being consulted with all relevant stakeholders. To ensure transparencies in drafting process, Cambodian Human Rights Committees is working with OHCHR office in Cambodia on the consultation process with all stakeholders and has held a regional and international consultation workshop on this draft law online with the participation of national and international experts, international human rights institutions, including ASEAN Intergovernmental Commissions on Human Rights, ICHA. Furthermore, Cambodian Human Rights Committee also allow public to comment on the draft law through the establishment of the channel Telegram, which so far has more than 200 members providing ongoing input into this draft law. Number three, accountabilities and remedy for human rights violations. Accountabilities of officialdom is always transparent, including in regard to corruption. Both administrative and criminal discipline are always applied to public officials who violate the law. There have been one after the other. In accordance with the dual Prime Minister for approach, self-reflection, showering, exfoliations, treatments, and surgery. Consistent statistics on disciplinary action and sentencings are all recorded by relevant institutions and made public. On the more international and historical front, in regard to extraordinary chambers in the courts of Cambodia, E3 dealing with the period of Khmer regimes in the mid-1970s, 4 cases, case 001, case 002/1, case 004/1, case 004/2 of also one case before E3 are judicially completed. The E3 work is important as historical record for the country and provide an informed and vetted narrative based on evidence collection, deliberations, and analysis. It is also educational as the open process enable the population to learn about legal proceedings and the tragic events of the past which must not be repeated. Over 300,000 people have witnessed the trial to date, and have become parts of that momentous socialization process. Number 4, overcrowding and COVID-19 spread in the prison. Cambodia has also worked very hard to resolve the issue of overcrowded detainees in prison. Issue of overcrowding in prison shall be addressed in accordance with applicable law and provision. The only release based on applicable legal procedure, which are also implemented now, such as measure amnesty and commutation of sentence, resolving prison overcrowding through the implementations of campaign to resolve the case backlog of court case in the trial chamber issued by Ministry of Justice, and conditional release, as well as other measures such as dismissal, decision to release on bail, acquittals, the complete executions of sentence, no more suspension of sentence, suspension with probation, pre-trial release order can ensure social security and significantly reduce the number of inmates in prison. Cambodia also consider and place measures in response to risk of COVID-19 inmates by strengthening health checkup, having detention management measure, and monitoring their entry and exit, and when they are with visitor. Obviously, the recent outbreak of COVID-19 in prison was under control. The royal government has taken into account the detainee welfare, having taken a number of necessary measures, such as transfer of detainee to other prison, legal consideration for the release of detainees who have committed minor offense, and having her release vaccinated inmate in prison and prepare for the third dose. Number 5, refresh media and expression. As regard to media, there is no violations of freedom of expression on internet. In fact, some websites operating online were blocked because they violate the law, as they do not rightly exercise the freedom of expression. The license of benevolent media companies who disseminate information on global pandemic were revoked due to the use of global pandemic disease as an excuse to spread intimidation, causing civil unrest. If only constructively criticism to the government response to COVID-19 was employed, no arrest was made. Freedom of press and expression does not mean freedom to insult, to fake information, or to defame someone. Right to expressions of opinion is not right to lie and discredit someone. All Western countries also have law punishing such a practice. Statements promoting hatred, xenophobia are also prohibited in Europe. For example, in regard with the establishment of National Internet Gateway, the purpose of sub-decree on National Internet Gateway is not to restrict the right of privacy and freedom of expression, or to collect the consumer data as wrongly alleged by some individual and organization, but to facilitate and manage internet connection, to strengthen national security and tech collection, and to help maintain social order and protect national culture. No provision in this sub-decree also right collections of consumer data or individual surveillance. National Internet Gateway is a means to advance fair and honest competition and transparency, and to stop illegal cross-border network connection, online gambling, pornography, child abuse, and frauds, and other cyber threats. The sub-decree has been consulted broadly among telecom experts, operators, and institutions concerned, and also adhere to principle of legality, necessity, and proportionality. Another example on the recent law enforcement against some environmental activists. It is neither because they are working to protect human rights, the environment, and society, nor because they are activists, but because they have engaged in criminal activities, violating the law with regard to insulting, disseminating false information, inciting violence in order to cause social unrest, insulting the king, and conspiracy, etc., of which the authority have clear evidence and legal basis for prosecution and judicial proceedings. The arrest, charge, and convictions of the aforesaid person are in accordance with the laws of Kingdom of Cambodia. In society governed by rule of law, individual rights and freedom shall be exercised within the framework of law, and the exercise of right beyond the limit of the law affect the right of other, they shall be responsible before the law. Number 6, freedom of assembly and association. Law on association and non-governmental organization aims safeguarding the rights to freedom of establishing association and non-governmental organization in the Kingdom of Cambodia in order to protect their legitimate interests and to protect the public interest, as well as to promote partnership cooperation between association and or NGO and the public authority for the development of Cambodian society. At the same time, association and NGO must act in a neutral manner toward all political parties and must ensure their integrity, transparency, and accountability. Through the partnership forum between Royal Government of Cambodia and civil society organizations, roughly 500 representatives of civil society organizations proposed to amend 14 articles of the law on association and non-governmental organizations. In this regard, the working group of Royal Government of Cambodia and civil society organizations have met and consulted 6 times. However, they have not fully finalized an agreement. The work is under discussions until an agreement is reached. Peaceful assembly and protest, in cooperation with the authority and in compliance with the security, safety, public health measures, are the exercise of rights guaranteed by the Constitution and the law. On the contrary, assembly and protest without notifying and cooperating with the authority, violating security, safety, and public health measures, causing violence and social unrest, affecting public order, national security, and right and freedom of others, as well as putting pressure on judiciary, which is an independent body, are violations of the law. And the authority must take all possible measures to prevent them, and protesters also held responsible before the applicable law. For example, in regard with the recent illegal protests of the workers at Nagawal, the authority found with a clear evidence that the leader of the union, as the organizers of the protest, have a malicious intention to destroy the company properties and incites the violence to cause the social unrest and insecurity by using the worker and protester as a political tool with financial, material, strategic support from the outsider political activists and illegal organizations. As a result, 3 of them have been arrested and sent to the court for further proceeding in accordance with Article 949 and 945 of Criminal Codes of Cambodia. In addition to this, other 3 protesters have also been arrested and charged of the obstruction of health measures against COVID-19 of the government in accordance with Article 11 of COVID-19 laws of Cambodia. Number 7, voting rights and participation in public life. Cambodia adheres to and respect the principle of pluralist liberal democracies as stipulated in Constitution of Kingdom of Cambodia. Cambodians have held national and commune Sangkat election for several mandates on its own, with free, fair, and non-violent participation. For example, the 29 July 2018 election was held normally, freely, correctly, fairly, and regularly, and 20 political parties compete, and the people had full freedom to vote as well. Currently, 45 political parties have registered, and the democratic process is proceeding as usual, and Cambodia is currently preparing for the run-up to Commune Sangkat election in June this year, and national election in July next year. Number 8, an update on the case of Mr. Kamsaka. He was arrested on 3rd September 2017 in connection with conspiracies with foreign powers to overthrow the legitimate government in Cambodia, acting in a color revolution fashion, following the color revolutions carried out in Yugoslavia and Serbia. The authority arrested him in connection with a criminal offense under Article 443 of the Penal Codes of the Kingdom of Cambodia on conspiracies with foreign power. He was detained on September 5, 2017, and released and placed under judicial supervision by the investigating judge, and shall perform certain obligations through the decision of September 9, 2018. The Phnom Penh Municipal Court held a hearing in relation to Mr. Kamsaka case. However, due to the spread of COVID-19 and at the request of his lawyer, the court decided to adjourn the hearing for a while. The court has now resumed the hearing as normal with transparent manner, which is open to public and all stakeholders who want to see and monitor the hearing. Furthermore, the proceeding against his cases, which is a serious crime related to national security and has taken only more than 3 years, must not be considered too long, comparing to other cases in Phnom Penh Municipal Court and the practice in developed countries. Number 9, update on mass trial in the case of November 9 event. The November 9 event was planned by a handful of overseas politicians led by Samrangsi. Number one, to incite the armed force not to listen to order and to revolt against the royal government. Number two, to inspire and incite the population across the country to rise their feet and act against the authority. Number three, to raise funds to support this activity. Thus, the November 9th plan is a coup plot, a serious crime that affects national security as stipulated in the criminal codes of Kingdom of Cambodia. Many people inside and outside the country involved in November 9th plan. However, because the plan was prevented and cracked down on time, the number of those involved is relatively small compared to the foreign cases. If the plan were carried out, the number of the people arrested would be higher. For this reason, what is important is not about having the number of many or more people, but it is about having irrefutable evidence. The coup plotter shall face the prosecution for attack, while those involved face a conspiratorial prosecution. Recently, the number of former opposition politicians were reinstated, bringing the total number of 31 members. They intended to form a political party, and so did many other former members of opposition party. However, they were barred by their leader, alleging and publicly declaring that they were traitors. This is a serious violation of their political rights. Madam Chair, committee members, ladies and gentlemen, Cambodia has worked hard and will work even harder and harder for the set goal of having prosperous people, a powerful nation with a democratic, just and civilized society in Cambodia. With that in mind, I would like to encourage the esteemed committee member to look at the overall positive picture, the strong development trends, and to share with Cambodia with both clear commitment, achievement, and progress gain, and the difficulty and challenges faced in the promotion and protections of human rights and freedoms in the Kingdom of Cambodia. With this, I would like to end my remark by expressing my sincere and utmost gratitude to Madam Chairs and committee members, and I look forward to having a constructive dialogue with you all. Thank you very much for your kind attention.
I wish to thank His Excellency, Mr. Chin Malin, Head of Delegation, for his opening statement. There is much that will be discussed during these three sessions, and we thank the Head of Delegation for the updates as well. So, colleagues, this morning we will be dealing with issues 1 to 9 of the list of issues. I have some speakers who have requested the floor from the committee. The first speaker on my list is Mr. Bulkan. Over to you, sir.
Thank you, Madam Chair, and good morning to you and to colleagues. And allow me to warmly welcome the delegation, both here with us and following online from the capital, and to wish you all a very good morning, very good day, good evening, and to say how much I look forward to this dialogue with you. I've noted very carefully your opening statements and the challenges that you've mentioned, challenges many of which face many of us in various parts of the world, such as a troubled history and the pandemic and all that has wrought on us. But I note as well that you, both here in Geneva and from the capital, your strong commitment to human rights and your statements that Cambodia has not shied away from its strong will to promote human rights. And that's the ethos and the framework with which I hope we can approach this dialogue. On that note, the committee has received very concerning and troubling information regarding the implementation of the ICCPR in Cambodia, particularly since the since the dissolution of the main opposition, Cambodian National Rescue Party in 2017, and the consequent situation as regards civic space in the country. On that note, Excellencies, I've paid careful attention to your opening statement and your concerns about the nature of our dialogue, and I wish to reassure you in terms of transparency and balance and non-politicization, the record and methods of work of this committee are public and well known. Let me again reassure you that our approach to this dialogue is based first and foremost on the reports that you have provided to us, the replies to the list of issues, and as well the information that we receive from civil society and from NGOs, which are all public and available on our websites. So in the course of our dialogue and the exchange of views, it will all be balanced, taking into account information from both sides and transparent. Ultimately, our goal is the same as you have expressed, that in the course of our discussions and ultimately with the recommendations that we make, the result will be an improvement, a meaningful improvement in the protection of human rights for all people in Cambodia. So bearing that in mind, Excellencies, let me turn to the list of issues, and I will start with the first issue, beginning with the institutional framework for the protection of human rights. At the domestic level, I wish to thank you, first of all, for the detailed replies to the questions which you have provided. However, although covenant rights are enshrined in domestic law, and there is ongoing training of judges and lawyers, as you've mentioned, our information is that there are significant gaps in the application of human rights standards. In light of this, can you provide the committee with instances where domestic courts have invoked the ICCPR? Please clarify for us whether national laws take precedence over the covenant in cases where there may be conflicts between the two. And if there are conflicts, how are those resolved? Does the state party have any plans to harmonize domestic laws in line with the covenant and to ensure that any such conflicts can be minimized and eliminated? If so, can you provide us with the salient details, such as the time frame for any such harmonization process and the opportunities for involving other stakeholders like members of the opposition, civil society, and minorities? If not, would the state party consider such a reform agenda? And finally, on this issue, in your reply, you informed us that the royal government has been thoroughly considering finding an appropriate time and circumstance to ratify optional protocols 1 and 2 of the covenant. We'd be grateful for an update in this regard. Both of these protocols cover crucial dimensions in the protection accorded by the ICCPR. And for this reason, accession without further delay would signal the state party's commitment to the standards and ideals of the covenant. Turning now to issue number 7 on the list of issues, that of equality. Both the third periodic report and the state party's replies to the list of issues allude to the efforts made by the state party to address discrimination against various minority groups. Nonetheless, the committee has received detailed information regarding gaps in this area. I'd like to draw your attention to information that there's a high level of underrepresentation of women in leadership and decision-making roles in all areas of public life, that there's extensive stigma and discrimination against LGBT persons, that there's systemic exclusion of the Vietnamese community in Cambodia, and finally, significant disadvantages faced by persons with disabilities, as reported by the Special Rapporteur on the situation of human rights in Cambodia. Disadvantages such as segregation within their communities and deprivation of liberty. Given these gaps in equality of treatment experienced by various communities, we would be grateful for more information in this area. Your reply to the list of issues states that the royal government has been making tremendous efforts to eliminate discrimination against women. through laws, policies, and programs. In this regard, please provide us with specific information on what laws, policies, and programs you've been referring to. Are there currently quotas in place to facilitate greater participation by women in the workforce? And if not, is that a reform that you might consider? Please advise the committee whether the state party intends to commit to general legislative reform to provide equal pay for men and women for comparable work, and crucially, whether the 1997 labor law will be revised to ensure that domestic workers are included and come within its protection. Please advise the committee whether the state party intends to address the precarious situation in which racial and ethnic minorities find themselves. For example, legislative reform to ensure the Khmer Krom, who have been living in Cambodia for more than 25 years, can acquire identity papers and ultimately citizenship, as well as reform to ensure that both Khmer Krom and Cambodians of Vietnamese descent obtain recognition of their rights to land. Given the widespread discrimination that LGBTI persons face in accessing employment, as well as discrimination and exclusion at the workplace and from the public at large, please advise whether there are any measures proposed by the state party to sensitize the public around sexual orientation and gender identity issues so as to reduce and ultimately eliminate discrimination and violence against them. And finally, Excellency, since issues of stigma, discrimination, and marginalization arise for a multiplicity of groups, so not just LGBT, but persons with disabilities and women and ethnic minorities, please advise whether the state party would revisit its position as stated in the replies to the list of issues, would revisit its position against adopting comprehensive anti-discrimination legislation. I thank you very much, and I look forward to your replies. Thank you, Chair.
Thank you, Mr. Bulkin. The next speaker on my list is Ms. Cran. Ms. Cran, you have the floor.
Thank you, Madam Chair, and I thank the delegation of Cambodia for your engagement with the committee this week. Today, I'm going to focus on issues 2 and 3 on the list of issues. Issue 2 deals with the establishment of a national human rights institution. In the late 1990s, Cambodia sought Canadian assistance for the establishment of a national human rights institution. And as an academic at the time, I was invited to explore the feasibility of this support. A major concern at that time, as it is now, was whether the type of institution the government had in mind would comply with the Paris Principles, which of course require legal, political, and operational independence from government. In Cambodia's 2015 dialogue with this committee, the committee was told that a draft law on a national human rights institution was under review, and in the committee's concluding observations, the committee expressed regret at the delay. Now, 7 years later, in your written replies, you indicated that there have been technical difficulties and circumstances in establishing the institution. This morning, you mentioned that some process steps have, in fact, been taken, and it's encouraging to hear those. We'd be grateful, though, for more specific details about the timelines for the completion of consultations with civil society, for the adoption of the draft law, and for when the institution will actually be in place. As you mentioned this morning, there have been consultations on the draft law, and I note that subsequent to some of those consultations, over 60 civil society organizations and trade unions signed a statement highlighting concerns about the independence and the effectiveness of the proposed institution. So please tell us which civil society groups have and will be consulted? Of course, civil society groups who may have critical views should also be consulted. And how will you ensure that civil society's views, including those critical ones, are taken into consideration in the formulation of the long-awaited draft law? Kindly also clarify measures that are being taken to ensure that the institution will in fact comply with the Paris Principles and will reflect the advice of the UN Office of the High Commissioner for Human Rights in Cambodia and the Special Rapporteur on the situation of human rights in Cambodia. I'll now turn to issue number 3 on anti-corruption measures. I note that the 2010 anti-corruption law established the Anti-Corruption Unit, an investigative team that conducts anti-corruption investigations in all sectors. It reports to the National Council Against Corruption, which in turn reports to the Prime Minister. Please tell us the current status of investigations by the unit of public officials for allegations of corruption, including as offenses such as offering, soliciting, or accepting bribes, illicit enrichment, and the abuse of power. I see that in 2019, 330 complaints were dealt with, including complaints of corruption in bidding and procurement. Of those complaints, could you please tell us how many public officials were tried for corruption, how many were found guilty, and what consequences did they face? We know that public officials are required to declare their assets to the Anti-Corruption Unit. Of course, this is important to increase transparency and to combat corruption. However, keeping these declarations confidential, as is done in Cambodia, obviously undermines the aim of transparency. So please explain why asset declarations are treated as confidential. And how do you confirm the declarations that are made by public officials? How do you know that they're accurate? Are they compared, for example, with income tax filings? I also note that the law prohibits failing to declare assets. What is the consequence for filing a false declaration? And please advise us how many officials have been found responsible for this offense in the last 5 years and what penalties they faced. Last year, I note that the Anti-Corruption Unit identified 9 officials who hadn't declared their assets. Please advise us on the action that was taken against them and a timeline for when legal proceedings will be instituted against them. Turning to another issue, and this is a serious concern for us, we understand that the Anti-Corruption Unit routinely harasses human rights defenders and political opposition by levying fabricated corruption charges against them. For example, in 2018, the unit conducted an investigation of 4 senior staff members of the NGO Cambodia Human Rights and Development Association, and they were prosecuted, and each of them was sentenced to 5 years imprisonment. I also note there's no protection for whistleblowers or for witnesses who report corruption, and this, of course, tends to create fear and a reluctance to report. So please explain the steps that you will take to ensure that the investigations by the Anti-Corruption Unit are legitimate, are independent from improper influence, and are not used to harass human rights defenders or those making complaints about corruption. The Anti-Corruption Unit recently stopped reporting on high-level public officials. It seems to me that focusing on high-level officials has great potential to prevent, to punish, to deter acts of corruption. Please explain to us why this procedure has stopped. And in 2015, a draft law on witnesses, experts, and victims, and in 2017, a draft law on reporting persons were under preparation. And I would be grateful if you could kindly advise us why these laws that have the aim of protecting those who make complaints against corruption, who witness corruption, who provide testimony, why have these draft laws not been adopted yet? If you could please advise us of their status, that would be most helpful. I also note that there have been numerous reports over time of corruption on land-related issues, including illegal logging, irregularities in granting contracts for development projects, and land grabbing. I mean, we all know that illegal logging is a well-known problem in Cambodia, and we know of the illegal logging operations in wildlife sanctuaries that has led to a major loss of Cambodia's tree cover. This illegal logging has been examined, and it's clear that the logging is perpetuated due in part to the Ministry of Environment officials and police taking bribes. And there are then long delays in conducting trials in land grabbing cases. So please provide us with information on the steps that you will take to effectively eliminate corruption that allows and encourages illegal logging operations. Please explain the steps that you are taking or plan to take to develop new law, policy, and programs to prevent corruption, specifically on land-related issues. And how do you plan to effectively investigate and prosecute public officials for land grabbing, and where they are found guilty, ensure they are punished? Corruption by public officials in granting contracts is also a long-standing problem. For example, a former Secretary of State was granted a contract to develop wetlands on the outskirts of Phnom Penh into ING Ing City in 2005. Thousands of families were subsequently displaced as a result, and the UN Office of the High Commissioner for Human Rights and NGOs recommended the cessation of the development of the wetlands. Please explain the steps that the state party has taken to investigate and punish corruption in granting development rights in this case and other such cases, and whether compensation was provided to the many displaced families. Please also tell us about the steps you'll take to ensure that corruption in granting contracts for land development projects is prevented. And finally, what are your plans? When specifically will you adopt the long-delayed law on access to information? I look forward to the delegation's replies. Thank you very much.
Thank you very much, Madam Cran. The next speaker on my list is Ms. Chamcha. Madame Chamcha, vous avez la parole.
Merci beaucoup, Madame la Présidente. Je salue la délégation cambodienne et souhaite à chacun de ses membres la cordiale bienvenue à ce dialogue. Merci à cette délégation pour tous les renseignements déjà reçus d'eux. Alors, dans le cadre de ce dialogue, l'honneur m'échoit d'obtenir de vous des renseignements complémentaires sur les questions numéro 4, 12, 15, 17 et 25. Mais ce matin, nous n'aborderons que la question numéro 4 sur l'état d'urgence. Le comité prend note que la loi relative à la gestion de la nation en période d'état d'urgence est la base juridique qui garantit la mise en œuvre du nouvel article 22 de la Constitution et confère au gouvernement royal le pouvoir de mettre en œuvre les mesures indispensables en période d'état d'urgence pour protéger la sécurité, l'ordre public, la vie et la santé de la population, ainsi que les biens et l'environnement. Compte tenu de l'observation générale numéro 29/2001 du Comité sur les dérogations aux dispositions du pacte en période d'état d'urgence, vous estimez dans votre rapport que les dérogations à certains droits énoncés dans les pactes internationaux sont strictement proportionnées au degré de gravité de l'état d'urgence et convenez qu'ils doivent être notifiés aux autres États partis par l'intermédiaire du secrétaire général de l'Organisation des Nations Unies, mais que le Royaume de Cambodge n'a pas déclaré l'état d'urgence, alors que vous aviez déclaré que cette disposition juridique devrait être mise en œuvre pour faire face à la pandémie du COVID-19. Prière nous expliquer dans quel contexte est appliquée la loi relative à la gestion de l'état d'urgence qui a été promulguée en 2020. Quelles sont les conditions requises pour déclarer un état d'urgence et si ce cadre juridique était nécessaire pour faire face à la pandémie? Quels sont les droits et libertés fondamentales qui peuvent être restreintes avec l'application de cette loi? Dans quelle mesure ces restrictions sont-elles compatibles avec les principes du droit international? Selon les informations que nous avons reçues, en mars 2021, et vous venez de le confirmer, la loi sur les mesures préventives contre la propagation de la COVID-19 et d'autres maladies contagieuses graves et dangereuses, loi sur la COVID-19, a été promulguée. Cette loi est-elle conforme aux standards internationaux? Vous avez donné une partie de la réponse, mais nous souhaitons revenir sur cette question. L'application de cette loi ne constitue-t-elle pas une entrave excessive à la liberté d'expression et de manifestation lorsqu'on prend un peu de recul? Il ressort du paragraphe 22 du rapport de l'État partie que la personne poursuivie a le droit de se faire assister par un conseil de son choix ou commis d'office à tous les stades de la procédure, conformément aux dispositions pertinentes du Code de procédure pénale. Selon les informations reçues, la loi COVID serait une arme utilisée par l'État partie pour réprimer les opposants au régime en place. Quelques questions méritent d'être posées. La procédure de comparution immédiate appliquée aux contrevenants à la loi COVID-19, selon ces renseignements, garantit-elle leurs droits sans l'assistance d'un avocat, comme ce serait souvent le cas? Pourriez-vous nous donner des chiffres actuels sur le nombre de personnes poursuivies en application de cette loi et revenir un peu sur les sanctions dont vous nous avez parlé ce matin? Ne trouvez-vous pas que ces sanctions, ou d'une manière générale, les sanctions prévues par les deux lois, à savoir la loi sur l'état d'urgence et la loi COVID, sont trop sévères et restrictives des libertés individuelles? Dernière question. En ce moment où la tendance dans le monde est à l'allègement des mesures liées au COVID-19, envisageriez-vous une révision de ces deux lois, sinon leur abrogation pure et simple dans l'avenir? Je vous remercie. J'ai hâte de recevoir vos réponses.
Merci beaucoup, Madame. The next speaker on my list is Mr. Furuya. Mr. Furuya.
Thank you, Madam Chairperson. Good afternoon to the members of the delegation who are in Phnom Penh, and good morning to the members of the delegation here in Geneva, and also to dear colleagues. I've joined my colleagues in thanking the delegation of Cambodia for participating in this meeting and having a dialogue with us for 3 days. Today, I'm going to address the issues in paragraph 5, 6, and 9 of the list of issues. I start with the issue of paragraph 5 concerning the fight against impunity of past human rights violations. As far as I understand, State Party has faced two issues of past human rights violations. One is gross and serious violations under Pol Pot regime in 1970s, about which I will raise some questions in relation to paragraph 6. The other is the grave violations taking place after 1991 Paris Peace Agreement, which I'm going to deal with from now on. In the concluding observations on the initial report adopted in 1999, the committee expressed its concern about the lack of action in regard to many deaths and disappearances that occurred from 1997 to 98, and in regard to the delay in completing the investigation of grenade attack on demonstrators occurred on 13th March 1997. In the previous concluding observations of 2015, the committee also expressed its concerns about the report that no one had been held accountable for the extrajudicial killings and other human rights abuses allegedly perpetrated by police, army, and gendarmerie. The committee considered that the State Party is obliged to investigate and prosecute the perpetrators and, where appropriate, punish them and provide reparation to the families of the victims, even though those violations took place more than 20 years ago. Please provide updated information on the measures taken to tackle with those past human rights violations occurred in 1990s, and also clarify the State Party's basic policies regarding the fight against impunity concerning those violation of human rights. Now I proceed to paragraph 6 concerning the extraordinary chambers in the Court of Cambodia, ECCC. Since the previous review in 2015, Supreme Court Chamber of ECCC has terminated 4 cases, namely Case 003 against Ms. Muto, Case 004 against M. Tito, Case 004/1 against M. Chaim, and Case 004/2 against Ao Am, due to the disagreement between the national and international co-investigating judges about whether those accused are subject to the ECCC personal jurisdiction as senior leaders or persons most responsible for crimes committed during the period of Pol Pot regime. This committee is not in the position of evaluating the decisions made by ECCC. However, it is important to clarify ECCC did not find that those accused were innocent of the serious crimes for which they are indicted. Rather, the termination simply means that ECCC is not appropriate forum to determine their criminal liability. Accordingly, the responsibility now rests with the Cambodian government and the domestic court. As a part of measures to fight against impunity, Cambodian government is required to ensure that those decisions by the ECCC would not send long messages to Cambodian society, particularly to the victims and younger generations. Furthermore, the Cambodian domestic courts are required to deliver justice by determining whether they are criminally responsible for these serious crimes. Now, my questions are, what measures has the State Party taken for the victims of crimes allegedly committed by those accused, and for Cambodian society in general after those termination decisions were made by the ECCC? Does the state party have any plan to try them before the domestic court instead of ECCC? Please indicate the next step state party plans to take. Now I move on to paragraph 9 concerning the right to life. The committee has received the allegation that in the state party, crimes committed against dissenting or critical voices, like human rights defenders and journalists, are often not investigated at all or investigated without transparency, independence, and impartiality. In its reply to the list of issues, State Party explained that investigation, prosecution, and trial of Mr. Kemray assassination and Mr. Solon Chan murder very briefly. However, I'm afraid these are not isolated incidents. In 2004, union leader Chia Bichir was killed. In 2007, union leader He Vuti was shot and killed. In 2012, environmental activist Chutu Vuti also shot dead. Between 1994 and 2014, 13 journalists were killed under suspicious circumstances after reporting on instances of government and military corruption. This is also applied to murder of Mr. Singh Kon, which occurred in November last year. The committee is aware with grave concern that there has been a serious criticism that no independent, impartial, and effective investigation was conducted to establish whether anyone else but the convicted person were involved in the killings, and investigator failed to look into the convicted person's backgrounds and possible ties to the government authorities. Under Article 6 of the Covenant, State Party has the obligation to take adequate measures to prevent, investigate, punish, and remedy arbitrary deprivation of life by the State Party's authorities, as well as private persons and entities. In regard to this obligation, please provide information about the about the number of the investigations, prosecutions, and convictions for the killings of opposition leaders, human rights defenders, and journalists since 2015, and the sentences imposed on those who are found guilty. Please clarify whether the state party is willing to reopen an independent and impartial investigation, for example, by the independent body of inquiry into these high-profile killings. In addition, please indicate whether the state party will agree to a visit to Cambodia by UN Special Rapporteur on extrajudicial summary or arbitrary executions. Lastly, please indicate the positive measures State Party has taken to protect human rights defenders and journalists from such assassinations and murders, and impact of these measures. Madam Chairperson, this ends my question. I would highly appreciate the answers from the delegation. Thank you very much indeed.
Thank you very much, Mr. Furuya. And the final speaker on my list is Mr. So. You have the floor, Mr. So.
Thank you, Madam Chair, for the floor. Good morning and good afternoon to those attending this session from Phnom Penh. Let me also join my colleagues in welcoming the delegation of Cambodia. I look forward to a genuine and meaningful dialogue in coming days, particularly noting that this year, Cambodia's leadership in promotion and protection of human rights is far more demanded at the chair of ASEAN. Today, I will address paragraph 8 with respect to violence against women. I appreciate the government explained in its written replies several policy measures taken as a result of the second National Action Plan on the prevention of violence against women, which ended 2018. Noting that the second National Action Plan had a particular focus on 4 key areas, namely gender-based violence in relation to alcohol abuse or child abuse, the role of media, and the training education. I would be interested to hear from delegation regarding what priority issues have been reflected in the third National Action Plan, which is from 2019 to 2023. In particular, I wonder how the third National Action Plan intends to address the reported high degree of societal tolerance of violence against women and a culture of victim blaming that is allegedly further instigated even by public officials. Moving on to paragraph 8b, the state party stated in its replies that the 2005 law on prevention of domestic violence and protection of victims is consistent with the provisions of the covenant, including the legal definition of domestic violence. However, I remain concerned that the Article 2 of the 2005 law does not guarantee adequate protections for those unmarried, dating, or other cohabiting persons. Besides, the provisions that unduly encourage non-judicial mediation, reconciliation, and/or financial compensation may result in impairing a victim's access to justice and leading to re-victimization. So my question is whether the state party ever considers conducting a thorough review and amending the 2005 law with a view to comprehensively define, properly investigate, and criminalize domestic violence. Lastly, I must put on record our serious concern about the complete lack of information provided by the state party regarding the number of complaints, investigations, prosecutions, and convictions for violence against women. The absence of such information effectively obstructs this committee from monitoring the implementation status of the covenant during the reporting period. While I repeat our request for the information again, I would like to hear from the delegation if there are any specific challenges or difficulties encountered by the state party in providing these statistical data and information. I thank you.
Thank you very much, Mr. So. So this concludes my list of speakers, and I would now propose to the delegation that we have a 10-minute break for the delegation to prepare its responses. So we will break now for 10 minutes and resume with the answers from the delegation.
some are quite new, but we will
Colleagues, we resume this meeting. I will hand over immediately to the delegation and Capital for its responses to the questions raised by my colleagues this morning. So over to Capital.
Okay. Thank, thanks so much, Madam Chair and the committee member for providing us the observations as well as questions for clarifications. We notice a lot of issues. Some are old and some are quite new, but we will try to do our best to explain to you, to update, to clarify to you as much as we can. If time not permitted and we cannot provide you all the information today, we will provide you in return later, because most of the issue are quite old, has taken long time ago, but we will try to update to you all those information and issues. So I would like to start first with some explanations on the observation and concerns that the committee have been raising so far. And after that, I will give the floor to my other colleagues to clarify some other issues related with the area. So first, in relation with the accusations of the violations of human rights principle and standard on the establishment on laws on management of nation in state emergencies, as well as the COVID-19 law, I would like to clarify, to explain a bit more on some reasoning on the establishments of this law, the necessity and some substance. What is this law exactly about, and why we can affirm that it is not the violations of the human rights principle or the restrictions of the rights and freedom of the people and all, which may be different from the accusations made by the other organizations and other activists so far. Here's the reasoning and the substance of these two laws and the necessity of making these two laws and the compliance with the international standard of human rights and legal frameworks of Cambodia. So first, I would like to explain about the laws on the management of nation in state of emergencies, the reasoning, the substance, and the compliance with the international standard of human rights. So the assertions that the laws on management of the nation in state of emergencies jeopardize human rights is unfounded and indicative of a selective and biased application of human rights. The fact is that this law is permissible by national and international human rights instruments, namely the Constitution of Cambodia, the Universal Declaration of Human Rights, and International Covenant on Civil and Political Rights. To respond to COVID-19 pandemic, many countries in the world have declared state of emergency and lockdown measures to prevent and contain the spread of this virus by inter alia provisionally derogating the people's freedom of movement, right to peaceful assembly, and privacy. Therefore, it is unfair to charge Cambodian for vital legislation. Law on management of the nation of state of emergencies, if drafted in compliance with Article 22 news of the Constitution of the Kingdom of Cambodia, in which a decision to place the country in state of emergency shall be made when the nation faces danger from a war-caused incident or an invasion by foreign force, a serious emergency affecting public health that lead to disease outbreak, utter chaos to national security and public order, as well as grave dangers that threaten or may cause nationwide spread. The establishment of the law on the management of nation in state of emergency is neither by nature a human rights violation nor a power gathering tool as alleged by a handful of opposition groups, but it is a valuable legal tool for the defense of the right to life, the right to peace, social stability, and development, which is the people's aspiration throughout the country and in compliance with the principle of rule of law in a democratic society. This law also provides a legal basis for implementing Article 22 new of the Constitution and a legal basis for determining government authority to introduce measures which are by nature prohibition or restrictions on the rights of citizens. However, this measure is indispensable in response to the state of emergency for purpose of protecting national security, public order, public life, health, as well as property and environment. Looking at international practice and a number of democratic countries in the region, Cambodian law adhere to a set of balanced and central norms and standards, which are neither too strict nor too loose. As Cambodian has studied the pattern of practice taken by those democratic countries, including Cambodian context. In international practice, certain countries adopt strict and rigorous standards, delegating all power to executive branch to take all necessary measures without control, while some others allow parliamentarian or and judicial control mechanism. And in the event of a serious emergency affecting national security, the use of martial law is even permitted. In regard with sanctions for obstruction and violations of government measures in this law, it is very necessary for effectiveness of law enforcement. Without sanction, law cannot be enforced. Comparing to law in many other advanced democratic countries, the sanction mechanism in Cambodia law is much lenient, whereas the law in other countries even permit the use of martial law in the event of a serious emergency affecting national security. In Cambodian law, power are not delegated to the executive branch to take measures without any limit, namely under the mechanism of parliamentary control up to two levels, the National Assembly and the Senate, Article 6 of the law. In accordance with the parliamentary system or democratic regime, including legal responsibilities of competent authorities who arbitrarily abuse their power, which violate and contradict the purpose of this law. Article 10 of the law. The circumstance state of emergency is unpredictable, and the declaration of placing the country in a state of emergency is to be considered when desperately needed for the purpose of safeguarding and maintaining security and public order, including life, health, interest, and properties of citizens and society as a whole. However, what is most important in this law is the review mechanism, which permit either the National Assembly or Senate to declare separately the state of emergency terminated when the situation permits. The critics so far seem to regurgitate their usual political attacks against the government measures or policies. In particular, they aim to politicize Prime Minister. It looked like they assume that the baby will be abused even before he is born. The critics should have reviewed the state of emergency law from a more objective lens than just a human rights attributes. As the world faces COVID-19 pandemic, there are growing concerns about potential danger to the nation and society, which necessitate emergency action. It is better to have law in place, even he does not need to use it now. It can be used when it is needed. So at the moment, the law has never been implemented because we can control the situations of the COVID-19 better. So it's not necessary to declare state of emergencies by the king. So when there is no necessity to declare state of emergency by the king, this law never be enforced, even it's already adopted. Another law that also necessary to protect the right to life of the people during COVID-19 situation and was wrongly alleged and criticized by some political activists is about COVID-19 law. In full, we call law on preventive measures against the spread of COVID-19 and other severe dangerous contagious disease. In short, we call COVID-19 law. Now let me explain a bit the reasoning, the necessity of this law and the compliance with the international standard of human rights by establishing this law. The establishment of COVID-19 law is neither by nature a human rights violation nor a powerful power gathering tool as alleged by a handful of opposition groups. But it is a valuable legal tool for the defense of the rights to life, the right to peace, social stability, public health, and development, which is the people's aspirations throughout the country, and in compliance with the principle of the rule of law in a democratic society. This law also provides a legal basis for determining government authority to introduce measures which are, by nature, prohibitions or restriction on the right of citizens. However, this measure is indispensable, proportionate, legitimate, and necessary in response to COVID-19 for the purpose of protecting national security, public order, public life, and health. In regard with the sanction for obstruction and violation of government measure in this law, it is very necessary for effectiveness of law enforcement. Without sanction, law cannot be enforced. Comparing to law in many other advanced democratic countries, the sanction mechanism in Cambodian law is much lenient. Harsher penalty and heavy fines in Cambodian law are reserved only for those acting with more serious consequence to the society, such as escaping from treatment center or hospital, infecting others intentionally, and under a clearly organized criminal enterprise. Comparing with penalty and fine in other countries, penalty and fines in Cambodian law are not any harsher and should not be a cause for any concern. Cambodians should not be unfair sign-up. In regard with the accusation that COVID-19 law enforcement is the infringement of privacy, I would like to clarify as the following. The disclosures of a limited person identities of certain individual hostile COVID-19 by authority is permissible in article of this law and relevant regulation. It is always a tough yet urgent decision which absolute necessity to speedily break the chance of community transmission associated with 20 February incidents in the interest of public health, safety, and security of enterprise population guaranteed by international law. Our past experience proved that the provisionals and time-bound choice have encouraged the promote early and timely tracings, testing, and quarantine of individuals involved in order to contribute to preclusions of uncontrollable cluster infection that certain parts of the world have terribly undergoing. Regarding right to privacy, Cambodians have clearly indicated an attempt to involve public participation to prevent the pandemic by the closures of personal information of those affected with COVID-19 so as to take precautionary action, especially with those who are not willing to comply with public health measures. Article 17 of ICCPR mentioned 1. No one shall be subject to arbitrary or unlawful interference with his privacy, family, home, or correspondence, nor to unlawful attack on his honor and reputation. Number 2, everyone has the right to protections of the law against such interference or attack. It is clearly indicated the right to privacy of those carry deadly virus is not counted. The stop of COVID-19 cure could was used closely to prevent the virus from spreading into community and was on the voluntary basis. No one has been punished for not using it. Notably, the Stop COVID-19 QR code system enable authority to carry out contact tracing, help individuals who have been exposed to COVID-19 to self-quarantine, get tested and treated timely to prevent the virus spreading. It is inappropriate to link this case to the right to privacy. This measure is used only for the tracing purpose in order to cut the sequence on time, not for revealing personal information of any individual. Thanks to this measure, many infected people have been traced to be quarantined, tested, treated on time. And as the result, we could control the COVID-19 situation better in Cambodia. So this is the substance, the reasoning, and the necessities, and the compliance with international standard of the legal framework during the COVID-19 pandemic, and necessary to protect the life of Cambodian people, and which is supported and appreciated by most of Cambodian people in this nation. Okay, so since we have many other issues that you have been raising so far, I would like to give the floor to my other colleague from Ministry of Information to highlight, to clarify on the issue of journalists, media, freedom of expression, and some other concern related with media that the committee member have been raising so far. So, Excellencies, Mr. Pon, please, the floor is yours.
Thank you very much, His Excellency, Chair of the Delegate, Madam Chair, ladies and gentlemen, in this meeting. In terms of the field of the information, I would like to provide you some more information related to 3 points. The first point, I would like to reaffirm about the process of the access on information law. The draft law on access to information by the Ministry of Information have been widely open to relevant partner and civil society organization for comprehensive comment and recommendation on the draft law through the establishment of a technical working group to prepare the draft law on access to information, abbreviation TWG A2I, with the following 3 main components. The first component, the royal government institution, include the Ministry of Information, Ministry of Justice, Ministry of National Assembly and Senate related to relation and inspection, and legal judicial council, office of the council minister. The second opponent, representatives of United Nations in Cambodia, UNESCO, and OHCHR, and the third, representatives of civil society organizations, including advocacy and policy institution, API, Center for Independent Media, CCIM, Club of Cambodian Journalists, CCJ, Cambodian Human Rights Defender Alliance, SRAC, Media and Communication Department, DMC, and Cambodian Women Media Center. The Ministry of Information also coordinate with and collaborate with the civil society organization, which are the member of the technical working group, to organize workshops and forums to gather input from target groups such as women, youth, vulnerable group, people with disability, and indigenous people, and key sectors such as education, environment, health, economy, mining, and energy, etc., in order to gather all of opinion to be discussed in the technical working group, and the input collected from the above target group and key sector are included in the content of this draft law. The 2020 annual report released by the United Nations Office in Cambodia also acknowledged that the draft law process involving the consultation forum with 1,200 stakeholders, including women, youth, vulnerable group, and people with disability, as well as indigenous people as well. The draft law is also recognized by the UN agency in Cambodia as UNESCO, mentioned that this draft law is widely open for discussion and consultation and should be a model for others draft law in Cambodia or in the region as well. Currently, the draft law have been finalized at the Interministerial Technical Working Group and the Ministry of Justice on penalty chapter. And the Ministry of Information hope that the draft law will be submitted for approval as soon as possible. In terms of this related to the draft law on access information, I would also to inform you that Cambodia is not the latest country in the region or in the world to will be have the access to information law. If we compare in the Asian region, Cambodia will be the fifth country which will have the law, and other fifth country in the region they do not think about the law yet. This is the commitment of our government to draft the law and hope that the law will be approved as soon as possible. The second point that I would like to express here is related to the harassment to journalists, harassment and intimidation to the journalists. In terms of this point, I would like to inform that freedom of press are guaranteed under the Constitution and regarded by the law on press. Journalists are provided full freedom to conduct their work without harassment, discrimination, or threat. Moreover, in an attempt to further promote freedom of expression, the royal government have even removed a clause related to defamation from the criminal code and provide guarantee that no individual shall be imprisoned for expressing his or her opinion. Article 20 of the press law stated that no person shall be arrested or subject to criminal charge as the result of expression of opinion. But in the dignity in individual need to be protected as well. Article 306 and 308 of the CCK state that defamation committed through the media shall be subjected to the provision of the press law, and an insult committed through the media shall be subjected to the provision of the press law. Article 10 of the press law stipulated that if any person believes that any article or text, even if the meaning of the article or text is implied, or any picture, drawing, or photograph of any press is false and harm his or her honor or dignity, that person have the right to demand retraction from or others a right to reply to the publisher of the statement, and their right to sue the charge of defamation, libel, or human mutilation which harm his or her honor or dignity. It goes without saying that if the court finds that a publication is false, the court acts on the filing of the complaint by the plaintiff in the civil action may order that publication to publish retraction, pay compensation or public retraction and pay compensation. Other abroad and indiscriminated allegation of the threat by harassment and intimidation against journalists, the royal government welcome more specific and fact-based complaint to be forwarded to the competent authority. The royal government treat the media as an indispensable partner in the framework of pluralist democratic society. The royal government is keen to work in the most constructive way with the professional and responsible journalists to improve the good governance in every aspect of society. B, the anti-corruption campaign, legal, judiciary, and public administration reform. One more thing in terms of the killing journalists. For the record, no journalist has been killed for political reasons since 2000. We recognize that journalism is a high-risk profession. The royal government strongly condemns all attacks on the freedom of press when acting in accordance with the law by media professionals, and we deploy any act violent against journalists. Unfortunately, not all the accidents were political motivated or related. Journalists' lack of understanding on news safety is also cause of accident. For example, rushing to cover a drug bus without precaution, entering premises on fire without respecting safety instructions. Another cause of tragic accident is the result of lack of moral code of ethics. There were many causes of that related to unequal personal business dealing, which are not totally unrelated to their profession. A few anecdotal cases at point are some journalists under the friction of investigative journalists set up illegal checkpoints to take bribe from the illegal logger and gold smuggler, land dispute, and extortion on corrupted activity, personal dispute, and traffic accident. From 1994 to 2020, there were 17 cases of such reported. Prosecutions were initiated for each case. The royal government regret that the attack against journalists are systematically attributed to the authority without any threat of evidence and based solely on the basis of rumors spread by ill-intentioned individual or NGO, denouncing this assault using the tirelessly repeated formula as widely political motivated. The wholesale of accusation address generally the effect of the assault, but rarely their cases. Thank you.
Okay, thanks so much, Excellency Mr. Fon from Ministry of Information for the update on the free press, media, and freedom of expression. Now I would like to give the floor to Excellency Mompanak, the Secretary of State from Ministry of Labor.
Sir, may I interrupt you, sir?
Yeah, please.
The time we are allotted is coming to an end. We have reached the end of the 2 hours because, as you know, for the hybrid meeting, we have the interpretation only for 2 hours. So we need to suspend the meeting and resume tomorrow morning. Could I ask the delegation then to perhaps tomorrow in the beginning complete its responses within 10 minutes? Would that be possible? So is the delegation in agreement? So, Dear colleagues and members of the delegation, this meeting now has to be adjourned. We're already a little over time. We will start tomorrow morning. And we will ask the delegation to complete within 10 minutes if possible its responses to today's questions so that we can proceed with a second round tomorrow in a timely manner. So this meeting is adjourned. Have a nice lunch, everyone.